I am very excited for this final panel dealing with the rule of law and EU values to the test of security. And I think it is a very sort of organic final roundtable because I think it ties on a lot of things we've discussed yesterday, but also just this morning on the role of values in sort of discussions about security. So this morning, is a geopolitical Europe also a Europe which may be sort of be a bit looser when it comes to rule of law requirements? I think that's an open question, and I think that's something you can address critically, and I think that's something we can do and we will do in this panel. So I'll very briefly sketch some sort of broad things on security and values, and then it's really up to the speakers. My job is to be as invisible as possible, but I will be very visible if you go over time. So I will sort of rigorously hold you to your 8 to 9 minutes, but it's just to sort of ensure time for conversation and discussion. To sort of frame this final panel, I've been thinking also over the course of the last day on what happens when you frame something as security, because it is something which we see all the time. This entire sort of conference is about security, but it's also a narrative, and something happens when you frame an issue in terms of security. Actors, events become threats to that security. Elon Musk is a threat to security. And I am the Hommes. I have a background in European law and history, and from sort of the history side of things, we know that once security gets a very special place, things can also happen very quickly. If a threat is framed as an existential threat, or if there's a push towards a permanent security, actions can go very far. Threats can be preemptive and preventively removed, because otherwise there is a persistent threat to your security. And I think it is no coincidence that the politician who has made an entire career out of being Mr. Security is in fact Benjamin Netanyahu. So elements of security is something we can see happening as we speak in Gaza. Europe has moved to the security language in many fields. I'm reminded of the speech of High Representative Josep Borrell, in which he framed Europe as a garden, which was threatened by the jungle, which was all around Europe. That is a security frame. I'm thinking of migration, where migrants are labeled threats to security. And those have impacts as to how those fields are treated legally, but also in reality. And here I think the link to values becomes very explicit. Fortress Europe is a reality. Security has a nice ring to it, feeling secure in one's own home. But what does it mean if sort of the walls of that home are militarized, defended increasingly by private actors as well? So I think those are questions one can have when discussing elements of security. Those values are very real as well. So we discussed yesterday the European way of life, and I would invite everyone to over lunch think of what on earth that would mean, a European way of life. But it grew controversial not because sort of the vagueness of the concept, but also because it was related to migration in the Commission, or the European Commissioner who was supposed to do it. And I think this tension between rule of law, European values are universal values, that's another question, such as human rights, the tension between those two is, I think, something we can take up without being naive. There is a value in being secure. So those elements are, I think, things we can take up in this panel. So that's why I'm really looking forward to what all the speakers will have to offer on those precise elements. So I'm thrilled to introduce the speakers. We have Jakub Jaraczewski, which I'm butchering, obviously the name, apologies in advance. Jakub is research coordinator at Democracy Reporting International. It's a Berlin-based NGO on supporting democracy, human rights, and the rule of law worldwide. So very much the practice theme. We have Nicole Scicluna, which I also butcher. Term, sorry.
That's okay.
So yesterday you don't need instruction. It was yesterday you spoke about expansion and accession to the EU. Now you will discussing more the international rule of law and how the EU relates to those elements. Third, we have Maciej Krogel, who is a lecturer at European Law and Faculty of Humanities, right around the corner here, who will address the relation between the EU common values of Article 2, so part of the, as Frans Timmermans would say, DNA of the EU, but how does it hold up to the other EU objectives, which we find in Article 3. And finally, you have Kati Cseres, very much in-house, associate professor of European law, focusing on basically everything to do with competition law, today discussing the state of Hungary and how it uses security also in terms of framing how it relates to the law. I will now turn on my invisible mode. Jakub, the floor is yours.
Thank you very much, and thank you for the invitation and for the opportunity to speak here to the Amsterdam Center for European Law and Governance for organizing this event, and also thank you for assembling a very diverse panel to talk about security. Frequently, conversation about security gravitates towards, let's say, as one gender and one kind of profile background, and I said we have a very nice group here. I want to talk about the intersection between the rule of law and security in the context of the upcoming Polish presidency of the EU, which Poland is assuming on the 1st of January. They haven't unveiled the official logo yet. However, I think that we can freely talk about what will be the themes and activities of this presidency, because Poland has already signaled that the theme of this presidency will be security and defense. So topics which are squarely within the interest of our event. But before, I wanted also to kind of set the frame by talking for a moment about how the 2025 Poland will be very much different from previous iterations of this country's presence within the European Union. And at the risk of overstepping my competences, I'm a lawyer, not a political scientist, but I'd like to make the observation that the Poland of today is, in terms of its interaction with the EU and in terms of its geopolitical positioning, a much different country, not only from the previous Poland of 8 years under the right-wing government of peace, which was very toxic in many ways in its relationship with the European Union and was very difficult to work with, but also from the previous iteration of Poland between 2007 and 2014, when it was also had a government led by Prime Minister Donald Tusk from 2007 to 2012. That was a Poland which was very much more about following in the footsteps of the others in terms of waiting for what Berlin and Washington will do first and then acting on its own. It was a Poland which was feeling secure. It was a Poland which believed that we achieved a peace for our lifetime of sorts, at least in Europe. And now today, the situation is very different. We have a Poland which is far more assertive in the European and global stage, a Poland which is no longer waiting for others, and in particular, its relationship with Germany has changed significantly. We have a Poland which is arming itself to the teeth and following more the idea of civis pacem para bellum. If you want peace, then you have to prepare for war. And we have a Poland which is looking elsewhere in terms of its alliances and in terms of its position. So it's a very different country. I think that the new government of, once again, Prime Minister Donald Tusk, but with a very different approach to certain things, is trying to answer to a certain desire to have Poland stand up, which actually was one of the mottos of the peace government, but the peace government interpreted standing up from their knees as confronting everyone and making themselves a problem for the EU. This Polish government is very much pro-EU and very much willing to cooperate, but also at the same time is kind of answering to the sentiment of making Poland well, not maybe great again, it's not to paraphrase Trump too much during this event, but definitely to have the country position itself in a much more assertive way than it was in the past. And so now when you talk to people in Warsaw, people from the Polish government, and you ask them about the Polish presidency, upcoming Polish presidency, they will tell you that this presidency will be about conjugating the word security through all cases. This is kind of the praise word for having security mainstream through all the areas that the Polish presidency will be working on through all the meetings and configurations of the council. Now, when the Polish people speak about conjugating something to all cases, you should be extremely worried about what comes next, because our language is so that when we conjugate, the word suddenly has 25 variants that are different depending on how it's being used, where it's positioned in the sentence, and what is the context. So please be worried about this when we say that we conjugate to all cases. But what it practically means that it's, the Polish government seems to be set to put security and defense at the heart of its presidency and to mainstream it through all areas, which also includes the rule of law, democracy and human rights, and the Polish support for values. And inevitably it means that Poland will be presiding over meetings of the council and the configurations where rule of law will be discussed, both internally and externally. It also means that those conversations will touch upon topics such as the rule of law situation in Hungary and in Slovakia, for example, and there is no hiding of the fact that the friendship of Visegrad 4 is kind of no more, and the idea of those four countries, Poland, Czechoslovakia, and Hungary, being close friends and supporting each other on everything, is at least for now dead. And Poland is looking elsewhere for its regional allies, more to the north, towards Baltics and Baltic countries. So we definitely won't see too much love from Poland towards Hungary or towards the Slovak government on those fronts. But in its ambition to promote the rule of law and security at the same time, and its undertaking to touch upon all of those bases during its 6 months of presidency, Poland is both enabled and challenged by a set of factors, and I'd like to mention a couple of those. When it comes to talking about EU values during the next presidency, it's important to say that Poland will come on the tail of the Hungarian presidency of the EU, which has been, well, fortunately not a huge disaster as some predicted, but still was extremely toxic, with Prime Minister Orban traveling around the world and meeting people with whom the EU is not talking, and kind of undermining the unity of the EU foreign policy. We had Hungary see its meetings in Brussels boycotted to some degree by other EU member states, as they did not want to sit in the same room and converse with a country which is blatantly breaking the rule of law and is undermining human rights. We have seen the recent Court of Justice hearing, where a vast majority of EU member states backed the Commission in a case against Hungary concerning LGBT rights. Basically, kind of walking after this and talking about the rule of law and human rights is low-hanging fruit and rather easy to do, because you are entering a room which has been just recently vacated by a government that has been absolutely hostile on those topics. So it's rather easy to come up with something that would be meaningful and that would be concrete and that would be seen as genuine and coherent in this situation. So that makes it easier for Poland to start a conversation on this. Poland is also a country which has significant capacity to lead on those topics, not only due to its size, but also due to the fact that it has long-standing experience in engaging on the rule of law and human rights in various forums and formats. And in particular, I would say, from my own experience, Poland has significant experience in promoting those values in multilateral engagement, and has been always active when it came to EU's action on the rule of law, democracy and human rights at the UN and the Council of Europe and the OSCE. So Poland would be kind of naturally well positioned to lead on this. I mean, for example, the Polish diplomatic presence in Geneva, where most of the human rights things are happening at the UN, has been traditionally very strong, and they've been always able to lead and to support whatever EU was doing. So there are several factors which are technical kind of factors and long-standing traditions which are enabling this. And finally, and most importantly, Poland is coming into this presidency while being in the middle of a process of restoring the rule of law in the country. The Polish government is currently trying to repair the judiciary. It's trying to restore its independence. It's trying to implement the judgments of the European Court of Human Rights and the Court of Justice of the EU, and is working on something which promises to become a kind of a unique playbook for restoring the rule of law after a long period of anti-democratic rule which damaged and diminished the rule of law. There is a lot of talk about how the Polish experiences that are happening right now could shape some kind of a template that could be then applied to other countries, to Hungary, for example, or to Slovakia or elsewhere, and how Poland is now producing political and legal solutions to very difficult questions that could be...
Which in final minutes.
In minutes, sorry. However, there are also constraining factors. And the first constraining factor is that this process of restoring the rule of law in Poland has had limited effect so far. The government has been able to achieve several things using secondary legislation and using things that don't have to go to the parliament. But the biggest problem is that significant reforms of the top courts require legislation. And this legislation is impossible because the president of Poland, Andrzej Duda, can effectively stop any bill dead, either by vetoing it, and this legislative veto cannot be rejected by the parliament because the ruling coalition lacks the votes to do so, requires a qualified majority, which is simply unattainable currently, or by sending it to the Constitutional Tribunal, which has been politically captured and is still practically under control of PiS and its allies, and this tribunal can simply stop the bill by either finding it not constitutional or simply not hearing the case at all and leaving it in a limbo. The second factor is that something what's been discussed already extensively over those 2 days. So just mentioning the trade-offs between security and the rule of law and the danger that in case if Russia, for example, making any more aggressive moves and moving on from sabotage and subterfuge into more open offensive action during the next 6 months, then the whole conversation about values and the rule of law could very easily just fall back and be replaced by urgent needs to have EU defend itself. And I don't think that we are anymore speaking about hypotheticals here. With the recent act of sabotage over the last few weeks, it's rather clear that we are entering a new phase of confrontation with Russia. And finally, Poland has a couple of skeletons in its closet which impede discussion on the rule of law and make it harder for the country to promote these values. Some of them are the making of the previous government. For example, the case of the use of Pegasus spyware, which is not yet fully resolved. There are investigations and criminal cases launched, but there is no full accountability yet and no full clarity as to how the spyware has been used. So, of course, the government is working on this, but until we have, let's say, some resolutions here that this process will not be complete, we have things which are very much making of this government, especially the situation on the Polish-Belarusian border and the introduction of the exclusion zone and the continued pushbacks and a very little change from the policy of the previous government of basically ignoring the rule of law and human rights on the Polish-Belarusian border and speaking to the fact that this crisis is in Poland considered hybrid warfare coming from Russia, and those people are not considered to be genuine refugees and migrant seekers, but instead being treated as a sort of ammunition used by Russia and Belarus against Poland. And so the social acceptance for these pushbacks and the way this is being handled is really high. And finally, there are some old skeletons in the closet. Poland has never fully meaningfully closed the door on several outstanding items, and I just wanted to bring one of the attention, which is the existence of the CIA black site in Poland in 2000s. There was the judgment of the European Court of Human Rights, which found Poland to violate human rights by allowing the US to operate this site. There was an investigation in Poland, which ultimately was dropped, and even then it was an investigation just against a single person and not an attempt to fully investigate a systemic problem. And of course, Poland paid out the compensation to the victim and has followed the judgment of the European Court of Human Rights. But this topic has pretty much died, and there never has been full accountability. And the trade-off between security and the rule of law in that case has been firmly in advantage of the security.
Maybe final sentence.
And final sentence is that I'd like to conclude with saying that it just shows how difficult it is for assume meaningful leadership on the rule of law if you want to promote security at the same time, and you have multiple factors which are holding you back, and it will make it more difficult to project those values outside. Thank you.
Okay, thank you. All right, so my focus for my intervention is going to be somewhat different, as was mentioned, right? So I want to focus on the nexus between the rule of law and security, but taking the international rule of law as my point of departure. And so what I mean by the international rule of law, just broadly in one sentence, is the EU's commitment to upholding international law in its various guises. And, you know, part of that, and I think some of this is going to follow on a little from what Kostya actually discussed yesterday in the panel, right? So what it means to uphold international law procedurally, but also substantively, right? Because really to uphold international law is to uphold a commitment to substantive principles and substantive values, and not merely to adhere to kind of legalistic procedures. Okay, so what made me decide to focus on this issue is the recent ICC arrest warrants for Benjamin Netanyahu and his former defense minister, and also one of the Hamas leaders who is probably actually dead, but it hasn't been confirmed. So that's what made me want to kind of focus my attention on this. And for the purposes of this panel, what most interests me is the reaction to the ICC arrest warrants in Europe, amongst both EU and national European leaders. Okay, but so before I come back to that, I want to briefly explain why I think that the EU's commitment to international law, to the international rule of law, is a security issue. It's obviously not only a security issue, right? It matters in and of itself, right? So, but it's also a security issue. And that is because, again, to put it very briefly and maybe a bit crudely, but the world in which might makes right is not a good world for the EU. That's not a world in which the EU is going to do well. You know, because for reasons that we've been discussing across these 2 days, that the EU is not in a strong position to guarantee its own security, and that might actually get worse, like if Trump follows through on some of what he says about NATO, etc. Okay, so on the contrary, the world in which the EU thrives is the world in which multilateralism thrives, in which multilateral institutions thrive, such as the International Criminal Court, and the world in which international law is respected. So the EU itself, of course, recognizes this, right? It recognizes this. So the commitment to international law is enshrined, like that is the EU's commitment to uphold international law, is enshrined in Article 3 of the Treaty on European Union. You know, and this comes out in various ways. Like one small example would be what Paula talked about yesterday with the Front Polisario litigation in the European Court of Justice, which was about the EU's obligations under international law with respect to Western Sahara, right? So, yeah. And of course, you know, coming to what we've been focusing on a lot, right, the Russian invasion of Ukraine. So, you know, the EU's kind of strong visceral reaction to Russia's full-scale invasion of Ukraine back in February 2022 was partly because, again, referring to some of what Kostya said, that, you know, the invasion was so kind of flatly illegal, right? It was just such a frontal assault on the UN Charter and on things like the prohibition on the use of force and the prohibition on conquest of territory, right, which is really foundational to the entire post-war international order. And, you know, the borrow with his garden and jungle, you know, that was rather clumsy and didn't go over well, right? That was not well put. But, you know, this is some of what he was getting at. Okay, so, you know, so I think that European leaders recognized and still recognize well that, you know, the Russian invasion of Ukraine doesn't just threaten Ukraine and doesn't just threaten European security in a very direct, immediate sense. It threatens the entire world order in which the EU is a meaningful actor. Okay, and then you have in turn, and this is like something of a digression, but somewhat related, you know, European shock and bafflement, right, that large parts of the global south didn't see it that way, right? Which you know, is not to say that many countries really clearly endorsed what Russia did, but many countries in the global south were basically reluctant to openly condemn the Russian invasion, okay? And there are many reasons for that. Some of which is that, the Russian narrative, to go back to that term, or the Russian alternate legality that Kostya talked about, actually does have some purchase in the global south. But part of it is also, perceptions, and not just perceptions, the actual reality of Western double standards and Western hypocrisy. So that brings me back to the ICC arrest warrants. And Vladimir Putin, of course, is also under an ICC arrest warrant. Okay, and that development was widely celebrated in Europe, right? Whereas the reaction to the warrant against Netanyahu, etc., has been more mixed. Okay, so this is the warrants were issued about a week ago, and so it's kind of an evolving situation in terms of how states are reacting to them. But so far as I've seen, at this stage, at the EU level, clear support for executing the warrants has come from Joseph Borrell. To my knowledge, Ursula von der Leyen hasn't made a statement on the issue, to my knowledge. At the national level, again, you see a range of reactions, right? So Ireland, Belgium, the Netherlands, Italy, as I've seen it, have signalled that their support, or that they would comply, or that they would execute the warrants. You've got Germany, which is conflicted between its special commitment to Israel and its commitment to the International Criminal Court, and like Annalena Baerbock and other government spokespeople have put out statements to the effect that they're examining the situation, and they're examining their obligations. And then obviously at the other extreme, you've got Viktor Orban, inviting Netanyahu to visit Hungary, which I don't think he's going to do, but so that's Orban, right, kind of being maximally contrarian and defiant. I just want to briefly highlight the current French position, though, and then I'll come to my conclusion, right? So I'm not going to go into details here. It's something we can come back to in the Q&A, but there actually is a legalistic case against the warrants. There is a legalistic case, which is essentially that the Rome Statute of the ICC cannot overrule customary international law that grants head of state immunity for states that are not party to the Rome Statute. So there is a legalistic case that we can talk more about. There is a legalistic case. And that's the case actually that France has now come out with, right? Which is different to the US style, the court is illegitimate, this is outrageous, this is, it's anti-Semitism, So that's like the US style. France is not making that kind of case of trashing the court, it's making this legalistic case. So 2 brief points on that. One, I think this is an example of strict legalism at the expense of substantive principles, which I think is a mistake morally, but also in terms of Europe's own interests, including its own security interests for the reasons I just said. And secondly, and obviously you would be aware probably already, the exact same case applies to Putin. Russia is not a party to the Rome Statute either. You cannot make this legalistic case for Netanyahu, not Putin. It's the same case. Okay. So to conclude, the positions are still evolving, and I can only hope that they'll kind of continue to evolve and cohere in a more positive direction of clear support for the ICC and the execution of the warrants. But I also just want to then conclude by saying, yesterday we talked about the nature of various threats facing Europe and also the source of those threats. The threat to multilateralism is one that emanates not only, but also from the United States, and probably will do more so under Trump, right? So, if the EU of Europe is going to be in any position to push back against that, it needs to be more kind of internally coherent first. I'll finish on that. Thank you.
Great. Cultural norms, basically. Maciej?
Yeah.
Okay.
Thank you. When I heard of this topic for the conference and also for the panel, this geopolitical awakening, this has inspired me to think of another phenomenon that we need to, I think, take note of if we think of the rule of law and security in the European Union, which is, I would say, normative awakening in the EU with regard to the rule of law in the member states. That has been happening over a decade now, more than a decade now. So the situation of the rule of law in the member states, I would claim, has provoked something that I would call a normative awakening on the side of the European institutions, but also more broadly the EU discourse of scholars, policymakers, lawyers. And my second point then would be that we can also see limitations of this normative awakening or normative approach or narrative, if you will. when we look at more broadly the questions that arise from the geopolitical situation now, and which pose teleological and axiological questions for the European Union, but also very practical questions. So first, we know that its common values from Article 2 TEU has been very much being interpreted by Court of Justice and then commented on by scholars, by lawyers, especially with regard to judicial independence. But the court really gave some concrete meaning to them and inferred concrete obligations from them. Culminating recently in framing common values as the identity of the European Union legal order, which of course corresponds to the quite fashionable, famous term of constitutional identity. So now the EU has its own identity as well, which resonated very much in the legal discourse among scholars who quite much welcomed this development as this reinforcement of values as identity. But this term of identity, which refers us to the core of something, the most specific features of a given polity, of a given system, I think it also shows quite a limitation of it when we look more broadly, normatively, at EU legal order, because after Article 2 TU comes Article 3 TU, which in the first paragraph says that the aim of the European Union is to promote peace, its values, from Article 2, and the well-being of its people. So promotion of values, I would say, is one of the three equal component parts of EU's aims, and I think there's nothing that would provoke us to interpret it differently, as that some of them is more important than the other. So when we think of identity or common values as identity, we should also ask why values among these three would be only the identity, or should identity also include other elements. And I think we can actually see an interesting thing in the case Russia Today France from 2022, decided by the General Court, in which the General Court dismissed the annulment action against the decision and regulation by the Council. These legal acts were aimed to combat Russian propaganda and impose a ban on media outlets spreading Russian propaganda in France. So the General Court dismissed the action of annulment and referred directly to Article 3.1 TU, including the general aim of the promotion of peace for the European Union, and confirmed that these legal acts in question pursue this aim of promotion and contribution to peace and democratic society. And what is significant, and I think quite striking, is that when you look at the reasoning of the court, but even at this very wording of the ruling, it very much parallels the judgments of the Court of Justice in cases on the rule of law conditionality, where the Court of Justice introduced the identity term. So it's this reasoning, or even the wording, is very much parallel. So the General Court also confirmed that this objective of promotion of peace is not purely symbolic or programmatic, but to the contrary, it may underpin concrete measures, and EU institutions cannot be criticized for imposing these measures and pursuing the specific aims of the promotion of peace. So this wording is very much as the Court of Justice in the identity/conditionality cases. But what is here also significant is that, well, I would say there is some cleavage in the more general normative discourse on common values. So, as I said, lawyers, policymakers are very much preoccupied when they think of values or identity with the rule of law situation. But on the other hand, there is this more sphere of this more geopolitical, or I would say material aims of the peace, well-being, which are a bit left aside, or at least not so much streamlined in the discourse on identity or values and so on. And I would say that this case of perhaps Russia today, or this direction set there, may be some sort of an avenue or thing to provoke us to think that a different direction is possible. Also thinking more broadly about the identity, the core or the normative basis of the European Union, however we define them. So not only this liberal, democratic, human rights, rule of law values, but also other objectives of the European Union from the treaties. And also, I think it will actually be very pertinent in the case of the accession of Ukraine, where you have the conditionality for the rule of law in Ukraine and the reform of institutions and fight against corruption. This is very much the rule of law thing during the accession process of Ukraine. On the other hand, you have these other objectives of peace and security. So I'm personally looking forward to seeing how these both sets of considerations or values will play in the context of Ukraine or other contexts. I think I will conclude with this. Thank you.
Waitingly, we're good time. Kati.
Yes, thank you. And let me know if I'm over time, because now there is also so much on the table to reflect on. So what I plan to do is talk from the perspective of Hungary, but not cry about Hungary. We will do it another time, but sort of offer some lessons because we are discussing or crying about Europe. So I hope I will get there. I would like to talk a little bit about narrative, why narratives matter, indeed how you introduced it, Wiebe, how the Hungarian government is using or misusing that narrative, how it's reflected in the legal constitutional framework, but then come to another narrative, what I recently heard at a conference where very exceptionally a member of the Hungarian government gave a speech. They never do that, especially not at a civil society organization who they just a few months earlier attacked with an investigation under a sovereignty law against foreign agents. So it was a very special setting, and the narrative there was, and I think that's also one of the things that I work on more and more, is they push back enormously when we start talking about values. And the narrative that the Minister of European Affairs presented there was the EU is becoming a system of values, while we agreed on a system of rules. And I try to show you that Hungary is problematic from the perspective of rules, especially internal market rules. And I think there is also a potential to redirect this discussion on identities, common values, to what is the core of the EU, which is the internal market. I'm sure I will be over time, so you stop me and then we shift to the discussion. So Hungary is great. It's a very, very strong example of using the narrative of security. Actually, Viktor Orbán already recognized it in 2007, exactly with the words that you used, Wiebe, that narratives can place actors and events in a different perspective. And he has been using this, so the words of war and peace have been of our daily lives, I think, at least for the past 5 or 6 years. So addressing people's physical security has been a very important part of the government's narrative, framing the news, the broadcasting, the public broadcasting through the media is just immense. So if you want to look for autonomy, security, sovereignty in almost each and every speech of the Prime Minister and his government, you will find that. So it's a very strong narrative. It's something that goes up even more at election time. It was the framing, and I think basically the reason why again they won with such a large majority in the last elections. And the narrative is not something I feel comfortable with because I am a lawyer. but we see how this narrative goes over into, once again, a legal framework. And that is how the Hungarian government has been using the state of danger. We actually, I think, often say in Hungary that we are living in a constant state of danger, because that's what is being communicated from the government. But using that specific concept to give the government, the executive, more and more centralized and exclusive power, without control, without constitutional control, without any control of the parliament or the constitutional court, to rule increasingly by decrees. And this started already in 2015 with the migration crisis. Then we were in the state of migration, emergency and crisis. That's where the first time when the Hungarian government has amended the enabling law, which provides it so in situations of emergency to act differently. So back then it has been specifically only targeted at migration. The more immense part of these emergency powers and changing this enabling act started with the pandemic. Then we were in the state of medical emergency, and I think it has never stopped since then, because this state of emergency is being prolonged each and every time. So the parliament is prolonging that situation. And since 2020, not only this, so first they used the Enabling Act to give the power to the government to rule by decree, once again without any constitutional guarantees that back then was part of the constitution, the fundamental law. So that's the first stage. And then they moved on to a more robust way of engraving it into the constitutional system with the 9th and the 10th Amendment of the fundamental law, where they first changed the definition of state of danger, which has given the government the possibility basically not link it to any event, but define by itself what is a state of danger. And the 10th Amendment, which I learned is, from a constitutional perspective, very particular, to link it to some kind of human catastrophe in a neighboring country, which would allow the government again to rule by decree and without constitutional guarantees. If you are more interested in that, there is a fantastic piece by Mészáros, which has just recently been published, and it's much more detailed on how this constitutional framing and legally framing of the emergency powers developed. But what I find interesting is that within this narrative and this whole legal constitutional framework, which is built out to provide the government at the core, you would think, to take measures which are required in a medical emergency, or if it's a migration emergency or a human catastrophe. But in fact, what we are seeing is that these powers are used in very unrelated areas. And that comes closer to my home, which is more, I will not talk about competition law today, but more economic law and economic regulation. So this has allowed them to take measures with regard to food supplies, price caps. There has been a recent case which was started by Spar, the Austrian company, against one of these price caps, so fixing the prices of certain basic food supplies, where they received a ridiculous fine for a ridiculous problem with regard to that. Fixing energy prices was an immensely important populist measure with the past three elections, and many other areas which are again not related to danger or states of emergency. And I think this shows and if I am on a mission, then that mission is to redirect a little bit the discussion from indeed the common values and the identity of the EU, because I think, and you can push back on this, I feel that a little bit the discussion got stuck at various levels. So there is this, we all feel for it, many probably of us agree with these common values, but the Hungarian government very strongly pushes back against that, like those values. And let's go back, I still remember that I think teaching it, the constitutional identity originates from the member states. I can't remember the court's formulation, but it's not an EU concept. It originates from the constitutional traditions of the member states. Now, I think the internal market rules, so when we talk about this kind of price fixing, with this narrative of we protect the consumers, the Hungarian consumers, and the court up there in Luxembourg does not understand that the Hungarian government is protecting its own citizens against inflation and high prices, etc. That's a question. Is this really protecting consumers? Being in a state of capping energy prices, keeping people unaware, basically climate change was named in an energy dependency, etc. Or it's doing exactly the reverse. But when we bring it back to the internal market rules, and okay, then I mentioned competition for a moment, and I don't have time. That's something which very much originates from the EU. It's not on the tradition of the member states, and I think that could be a new narrative and a new way to push this rule of law and what are the values in the EU back in the discussion with the Hungarian government, and show that there are these cases which come back to the very core and foundation of the EU, irrespective of these national identities and constitutional traditions. Thank you.
Thanks so much. I have plenty of questions myself, but I will leave them because I think I've heard a lot of elements which I'm sure sort of demand a bit further discussion, particularly with the audience. We have growth in executive power, we have the need for unity within the EU. Those two can sort of combined can all lead to funny things. So I would really like to open the floor immediately for questions. So let's collect a few, do a round of answers, and then we move on from there. I see 1, 2, 3, 4. I see too many hands. So let's sort of move slightly like a snake towards the end. So I have Maria, I have speaker, sorry, I have Annette, I have Piotr, and I have you. So let's sort of jump and I'll sort of, yeah, Maria.
Thanks, everyone. This was a very interesting panel. I have a question, particularly to Kati and Maciej, about, this discussion with values being stuck. I feel there is a lot of purchase in it, but I'm still not clearly understanding sort of, what makes it get stuck and what do we, what sense do we make of this? So as Maciej rightly said, this whole narrative of EU values now being used to fight for rights in Hungary, for rights in Poland, LGBTQ rights, but also other freedoms is very popular, particularly among EU law scholars. So von Bogdandy, a leading German law scholar, has written a book. Published a book this year where he basically says, because we have Article 2 and all the values in Article 2, and now the court is using that, developing this case law about values, this is how we are going to arrive at a European society. This is how we're going to build a society through law, because European law gives us these values. And I mean, I have many issues with that construction, but it kind of, it reflects one way in which law scholars often think about these matters. And I am intrigued by, so my question is this, to both of you. Can you make it a bit more specific and concrete? Where are the conflicts? So for Maciej, for instance, where do we see conflicts, tensions playing out between peace, well-being on the one hand and values on the other hand? What are the test cases? If you think about the case against Hungary now for this LGBTQ legislation, where concretely are the conflicts? And for Kati also, I mean, you're suggesting maybe better to go the sort of the more economic route and fight Hungary, with the traditional tools that the EU has, this economic market law and so on. But I mean, that is of course also, there's a long-standing critique that the EU is doing everything through an economic narrative, and how about human rights? And so what do you say about that? And here also for you, where exactly do we get stuck? And isn't this a principled stance on the part of the EU finally to fight for human rights instead of markets? Thanks.
What's that?
Thanks. I have a question to Nicole, which has to do with the EU and double standards. Let me just two observations. First of all, I just approach this. I'm an American. I would describe myself as a liberal, non-Jewish Zionist who I yield to no one in my anger, and I choose another word, but contempt for Netanyahu and the thug government that he's organized. But, going back to what the chairman said, although Netanyahu instrumentalizes the security narrative in terrible directions, he's not inventing it, okay? I mean, in a ways that it might be invented in Hungary. The second observation is just an odd historical thing, which I'm actually puzzled about, which is that the EU, or actually not the EU, European countries, I mean, you talked about how Germany is conflicted. If you compare, because October 7th was like 50 years after the 73 war. And if you compare European opposition to Israel in 1973 to their support for Israel now, it's really quite striking. I mean, there was huge transatlantic divisions in 1973 about the October War, where now Israel's behavior is, objectively much worse. I mean, and yet you don't see that kind of transatlantic division, which I find it very interesting. Mm-hmm. Now, but about double standards, and now I'm going to move away from Israel. But I was really, really struck by when you said, and I agree with you totally, that the EU cannot afford to flout legal standards and multilateral expectations. And I'm not sure exactly how you put it, but that the EU, and this is almost a carbon copy or a real echo of the speech that Robin Cook gave when he resigned from the Blair government over the Iraq War. And I don't know if you know that speech or if you read it, but it was a little sleight of hand play, because he said, the United States is a superpower and it can afford to go it alone. The United Kingdom is a middle power and it cannot afford to flout these rules and this multilateralism. It depends on it, its relationship with Europe, with NATO, and so forth. But he then had to make an argument about why he supported, as he strongly did as foreign secretary, the intervention in Kosovo. Without a Security Council resolution backing it, where he was opposing the intervention in Iraq without a Security Council resolution backing it. And his answer was, well, in Kosovo, there was no doubt of the legitimacy of the operation. We had the support of NATO. We had the support of the EU. All our major partners supported it. The legitimacy was obvious. But he was playing a little trick there, because he was not investing legitimacy in the United Nations Security Council. So I just wonder if you might comment on that.
Let's take a couple more. I have a person in with the sort of reddish. Yeah, that will be you. If you could introduce yourself, please. It would be great.
Yeah, I'm Marcel. I'm a student here in QPA. Should I stand up?
Wow, whatever floats your boat.
Okay, I wanted to ask a bit more related to also the panels of yesterday and the previous one today about well, I saw kind of a conflict in the approach to the rule of law itself, because yesterday we heard talking about when it comes to the EU's external action, creative legal solutions about, maybe strengthening maybe not necessarily changing the treaties, but rather finding another way to strengthen the EU's voice towards the outside. And then also at the same time, the previous panel, there was discussion of, what if maybe it's time for the EU also not to necessarily follow the international rules because, the other parties are not following it. So it might put us at a competitive disadvantage to do so. But at the same time, I think what we see is that within the EU, member states not necessarily following the rule of law and, deviating from a rules-based order can also pose a security risk in the sense that we see the same leaders who are, rolling back on the rule of law are also, they also seem to or tend to be, friends with Putin, for example, or just in general, in some ways supporting or pushing the Russian narrative, which I think might hurt European security. So I was wondering for any of you if we could maybe try to reconcile the need for following the rules of law within the EU itself, but then at the same time maybe departing from them outside. That also seems a bit hypocritical to me, if I may. Thank you.
Thanks. I have Annette and Piotr, and then we'll give you the floor.
Yeah, thank you, and thank you for this panel. It's very interesting and again thought-provoking panel. I have a question for Jakub, inspired by Kati's remark that where is the Court of Justice? And I'm working in the field of migration law, and it is in the pushback. So Poland started to push back once this instrumentalization, as it is called, happened. Lithuania and Finland did sort of the same thing, and they also changed their act on foreign nationals in a quite dubious way. My question is, where was the European Commission there? It seemed to look the other way in the beginning. So it's, I think, and now finally the EU, the EU has acted with a regulation on force majeure, crisis situations, what to do in these type of situations. But it only applies as of July 2026. So the EU's role in, let's say, allowing this pushbacks and not obeying the rule of law is also questionable, hypocritical maybe. And that you can reflect on it.
Yes. And then we have Piotr.
Thank you. Piotr Pauza here at the ACELG. Well, I have a question. Came most interested to hear from Jakub, but also I'll be very curious to hear maybe other speakers if you want to. So try to frame it carefully. How would you evaluate attempts made with the objective to restoring the rule of law that entail breaking the rules established by the previous government in bad faith? An example from the Polish case, the Jaraczewski government established an institution of the state prosecutor, which was parallel to the existing institution of the general prosecutor, that would have supervisory and legal powers over all prosecutors in the country. And it was a party loyalist was appointed to this institution, and the current Polish government essentially said, "Oh, the appointment was illegal. Let's throw the guy away," and they appointed a new prosecutor. I mean, in a normal situation, we could ask the Constitutional Court to litigate in such a dispute. But here, I mean, in the Polish case, it was unavailable. I'm curious what you think about, such actions, because I imagine if there's a change of power in Hungary or in the United States, and in 5 years, we could witness similar situations, how this affects the legitimacy, the ideal of restoring the rule of law. Thanks.
I think it's very clear. I think so. We have 5 questions. So, where are the conflicts? EU has sort of uphold of multilateralism, upkeeping rule of law internally, but potentially sort of not externally, pushbacks, and thus the EU. So, what is the role of the EU there? And reconstructing the rule of law through illiberal means. And I think we can sort of go from that direction to this direction because they follow sort of quite logically in that sense. So, Maciej, if you take the first one.
Okay, so responding to Maria, I wouldn't say necessarily there is a conflict actually, or rather that it really depends on framing and how the discourse is framing it, because I think it's totally avoidable to see it as conflicting values or aims. It's just that, for instance, the case with corruption that the conditionality regulation is aimed to fight, that it has this, of course, very strong rule of law component or rule of law relevance, but it has also way more broad societal relevance of it's permeating various institutions, national institutions, and so on. So I would say that these components here are going together, but the focus is on the rule of law in how the court has framed it and also how the discourse is framing it. And I agree with, also I'm not so convinced for these framings of European society, for instance, for one reason, because I don't see what is the explanatory added value in such framings, right? So what it gives us, but also what is the added value of the using of the term identity in the court's rulings, because the court could have decided this conditionality rulings without invoking identity completely, right? I heard that it was like really in response to claims made by authorities of Poland and Hungary that what they do is protecting their identities, and so it was like sort of counterpart to pursue the identity of the European Union, but also why values are being stuck. I don't know. Maybe it's here more interesting to hear from Kati, because she introduced this term of being stuck, but I see it like that. Look, when for many years Article 7 TU procedure was the main procedure, the most commonly referred tool to deal with the rule of law. Then also the conditionality. So both were sort of designed in a way like, okay, let us cut off the member state in question from participation in the European Union, let's suspend their rights, and hopefully to nudge them to come back to the right path. But now, and especially since the crisis and the pandemic and the war and so on, I think the problem is, okay, we can suspend some rights of Hungary, but we still have Hungary in the middle of Europe. We can geographically remove it. What is happening with visas policy in Hungary, for instance, which are very worrisome. So I think it's in this way, this thinking, this design is a little bit like pre-war design of the tools to protect the rule of law, and maybe that's part of why it's stuck. I don't know. I'm curious what Kati thinks.
On Article 7. Yes, I think that's a good example. I am not a fan of that, for the reason why I was also not a fan of discussions why Hungary shouldn't have the presidency, and that's mixing the Hungarian government with the Hungarian people. None of them is very supportive for them. But back to your question, I agree with Maciej. It's not indeed, maybe it has came over to do more the technocratic economic core instead of democracy and standing up for human rights. That's indeed not, I should be more nuanced about it. What I see is that it has been very much framed from this human rights, rule of law, democracy perspective. And what we see, and let me give you an example with the consumer thing. And it may give also an answer to enlargement and many other things. What I see, for example, in Hungary, but I suspect also in other countries, consumer protection was really a ticking the box exercise in the enlargement process. I mean, it wouldn't have happened in many of these countries without the EU putting it on the table. These are the conditions, you fulfill it, and then you are part of the club. What you see in Hungary is actually an institutional breakdown of eliminating a relatively independent authority who was in charge of consumer law enforcement, putting it under the government. So breaking down, in my eyes, why consumer law and protection has been put there, while you have this consumer protection by the Hungarian government of and the LGBTQI case. I know it's very much for many of you an Article 2 case, but it started with the enforcement is consumer protection. It's consumer authorities who issue those fines on if you sell books without, putting in putting into plastic foil, if the bookshop is within 200 meters, etc., etc. It's very much a case which shows us also the narrative, the child protection law. If you put it next to government programs on consumer law, it became a family protection program. Now, who is the family in Hungary? Is the mother is a woman and the father is a man. It's a very anti-gender policy as well. So through this, you see consumer protection, as we understand it as a value in the EU, has been broken down and filled in with an anti-gender populist protection, very protectionist feeling. I mean, these energy policies, gas, etc. I mean, there are immense discussions there as well. How it protects, isolates the market. It's very aggressively against foreign-owned companies, etc. And I think linking these different puzzles together would be the way forward. And also for the Commission, because in the Commission, sorry, this is the last one. This is all split up. DG Justice, I understand now that the incoming commissioner does have already this internal market lens, but I'm wondering whether all the others will have, and there is a certain competition within the Commission as well.
Okay, thank you, Dana, for the comments. You've given me a lot there to think about. Yeah, I mean, the difference between European countries' positions in 1973 and now is not something I understand, actually. So I really don't. On the EU can't afford to flout international law, and okay, I'm not familiar with Robin Cook's resignation speech, so I should probably look at that. But I was having this discussion yesterday, actually, after the first panel, just with some people privately, right, about okay, if I can just say something about Iraq and something about Kosovo, okay. At the time of the Russian invasion of Ukraine, there was and I'm sorry to reference a Twitter debate, but it was a Twitter debate. It was a very interesting Twitter debate amongst international lawyers, essentially over whether Russia's invasion of Ukraine was more illegal than the US invasion of Iraq. Okay, which of course on one level, like it's illegal or it's not illegal, right? How could it be more illegal? But you can probably kind of get where that was going, right? Because, well, firstly, and this is something when I discuss it with my students, it just reminds me that I'm getting old, because I do actually remember these debates, right? And I remember Colin Powell with his little vial, in the Security Council, of whatever it was meant to be. The US made a concerted effort, a really strong effort, in the UK too, to make a legal case for the invasion of Iraq. And the legal case wasn't accepted, and then they did it anyway.
Robin Cook was saying.
Yeah, okay, so that's what happened there, right? But they really did try to make a legal case, and they rolled out, Colin Powell, who was like the most popular of the Bush administration, et cetera, right? So they tried, and then they did it anyway, because that's what the US can do, right? The US can get away with that, okay? Whereas, I think, as Kati was saying, what Russia's done with Ukraine, it's just you can't really reasonably make some kind of legal case for that, right? And also it's a war for conquest of territory, right? Which whatever the US was trying to do in Iraq, it wasn't like quite that. But still, of course, like illegal is illegal, and it is this kind of debate. And when people say, no, but this is worse, this is more illegal, this is the kind of thing that I think frustrates a lot of people in the global south, right? Because this is exactly like Western hypocrisy. No, but it was less illegal when we did it because we had reasons, and this is just worse, right? So that just doesn't convince a lot of people. Kosovo, quickly. I'm surprised it didn't come up at all yesterday again, because like I think that Putin has dined out on Kosovo for 20 years. Has just dined out on it. I teach a course on the politics of international law, and I use Kosovo for so many things, right? So, humanitarian intervention, like the jus ad bellum, like the right to go to war, humanitarian intervention, self-determination and secessionism, and international humanitarian law, looking at the particular ways the intervention went. And you can see some parallels, right? Like in the Kosovo conflict, like the most single effective strike was when they finally decided to hit the electricity grid, right? So then the whole thing about civilian infrastructure, and you see it now like with Ukraine. Okay, so Kosovo, I think Putin has dined out on, right, ever since. I can't give you a satisfactory response because I have very, very mixed feelings in that I actually do kind of deep down think it was justified, and yet it was illegal. So then I'm in Robin Cook's position, right? And what you said was exactly, I'm sorry, I'm a bit jet lagged, so details aren't coming to me, but there was then that International Commission for Kosovo, which published a report, and like the headline of the report pretty much was illegal but legitimate, right? Illegal but legitimate. And that's actually what prompted then the whole responsibility to protect debate, right, in the United Nations, which is like, it was then tried once with Libya and never again because it turned into a regime change. Libya is another one, right? So, legitimacy versus legality, again, this is the kind of thing that's exactly like, oh no, but the rules aren't for us, because when we do it, it's legitimate. So, and the particular problems Kosovo posed for the EU, yes, the Kosovo posed problems for the EU on many, many levels, right? The fact that they couldn't do anything at all to intervene, right? It's our backyard and we can do it. No, actually, it had to be NATO. The whole issue over the legality of it. Other things as well, like the decisions to recognize, the independence, and which is an ongoing problem because not all EU member states recognize Kosovo, right? So it's Kosovo is like, and and at the time the US really carefully tried to frame Kosovo as not a precedent for anything. Sorry, and that's it's purely exceptional. But this is exactly the problem. Not everyone is not going to treat it as purely exceptional just because you say so.
Yeah.
Thank you very much for this question, because the question with the pushbacks is certainly one of the most burning challenges to EU values and how they are being treated and practiced by member states. I think that to answer the question why there is no Commission action on this, I think the answer is unfortunately political, and that there is a political consensus which is resulting in the decision-making bodies of the EU not taking any action towards member states, because it's not just the story of Poland, it's also the story of Lithuania acting this way on the border. And I think that this political consensus comes out of a couple of factors. One factor is that the sentiments against migration in EU member states, and the fact that the concept of the EU becoming Festum Europa and closing its doors to people from the outside is extremely strong in many EU member states, and it fuels the far right, and the consensus seems to be not to provide the far right with the fuel, and the best way to do that is to limit migration and to push back against irregular movement of those people. And I think also that an important factor in this political consensus is that Poland in particular is a large EU member state, which is currently run by a centrist government led by a prime minister who comes from EPP. It is a country which is bordering to enemies of the EU. It is a country which is very pro-European in the vast majority of regards. And I think that when Tusk came into power, there was a breath of relief in Brussels over the fact that now we're going to have hopefully a strong cooperative Poland, which will be open to collaboration on many fronts. And we kind of need to make sure that we don't make life too hard for the Polish government in return. And it has manifested in many ways. It has manifested in the fact that the European Commission dropped the Article 7 procedure against Poland and released the Recovery Fund and Cohesion Funds, which were held back over rule of law and fundamental rights concerns. And they did that all based on mostly action plans and promises from the Polish government and limited action to restore the rule of law, as I mentioned earlier, held back by the fact that the legislation won't be possible probably until the next presidential election in May 2025. So it seems like there was an appetite to help Poland and very little appetite to make life harder for Poland. And this has resulted in the common policy. By the way, it's just not those two countries. Finland, for example, made an amendment to its constitution to allow limiting the right to asylum and being able to seek refugee status. And that also did not provoke any action from the Commission. So I think that this political consensus holds and will hold for foreseeable future, especially now with the even stronger presence of the far right in the European Parliament and the influence. So this is definitely a crisis, I would say, of a certain cohesion of EU when it comes to values and enforcing them. But I'm not seeing, unfortunately, any clear view towards that ending quickly.
So I think we still have the question of Piotr on how to repair rule of law using illiberal means. And we have the students' question, obviously, on how do we see this tension between upholding rule of law internally, whilst there seems to be a movement to rule breaking on the international level. Go for it.
Yes, so as soon as I have the mic already, so let me continue. The question on breaking the rule of law to repair the rule of law, this is going to be actually, I think, a fascinating element of this rule of law repair playbook that Poland is producing. For those of you who haven't been following the story, several actions to repair the rule of law in Poland, to restore the let's say the public media into some sort of independence, to be able to change and adjust the prosecution office. All of this was done in the means which some lawyers will call skirting the boundaries of law, some will call bending it, and some would call outright breaking it. And it has been extremely challenging because it could not be done otherwise under the current circumstances. There is no way to easily legislate with President Duda resisting any notions to change what the party he originates from brought about over the last 8 years. Similarly, there is no easy way to amend the Polish constitution. It also requires qualified majorities, which are unattainable in the parliament. So that left with the government with a difficult question. Do we do things in a way that lawyers will, let's say, look very badly on? Or do we just allow the previous political force to defeat us through all the elements which they have installed and made it extremely difficult to remove them? And this trade-off has been resolved by the Polish government in the way that, yes, we're just going to do it, and we're going to wrestle back control over the prosecution's office, over the public media. We're going to ignore the constitutional court. Since March this year, the government is simply refusing to publish the decisions of the Polish Constitutional Tribunal, thus rendering them technically not in force, because the law says that the judgments of the Constitutional Tribunal need to be officially published by the government, and the government is not doing that. And it has so far not yielded any significant political cost, at least from what I'm looking at. There has been no significant loss of support for the government, which opens the question of what is the threshold and how far can you go bending the rules in order to save the rules. We don't have yet full answer to this because I think the story has still some elements to play out. And it will be definitely a very interesting question come summer next year after the presidential elections, if a candidate who is supporting rule of law reform will win, then I think that things will start simply moving the way they should, and new laws will be passed by the parliament, signed into force by the president, and things will stay out to play out a little bit as we should expect. But if, for example, the elections will yield a president aligned with peace who will become obstructive again, then it will be very interesting to see what the Polish government will do and how it will try to cope with that. So there is no easy answer, and I think that unfortunately, and a lot of lawyers close to ideas of rule of law and human rights won't like the answer, is that in order to be effective, sometimes you have to break things. And this is the answer that the Polish government is currently giving you. And we will see in a couple of years whether this has been the correct answer or perhaps they have been mistaken. But so far from when I'm looking, it kind of looks like it's working out for them. So we will see what happens next.
Yeah. Nicole, if I can put you on the spot, in order to be effective, you have to break the rules. Also, in terms of the students' question on rule of law, holding international rule of law and internal cohesion, could you maybe reflect on that? This is a very big question.
Yeah, I mean, I agree, right? So, and you're right. We will see in a couple of years if it's the right answer in the Polish case. Sure, sometimes to be effective, but this is, yeah, I mean, this is what the US does a lot, right? Because it can. So you just act effectively in your interests. But of course, the question is about the long-term costs, and that was something else. So, you know, going back to like Kosovo and Iraq, and even though I'm like very sympathetic in relation to Kosovo, not Iraq, but Kosovo, like obviously every breach of the law just chips away at that facade, right? And especially international law, like the Polish domestic situation might be different, but you know, again, when I teach this, and I don't know anyone who teaches international law, like the first problem you have with students is convincing them that it's a real thing that really exists. And so, yeah, so it's out there somehow, and it's not as easy to see, and it's not as like, it's not institutionalized in the same way as domestic law, right? So it's more vulnerable to this, you know, like every major breach just chips away at that foundation. So yes, if you're a state that is able to act effectively, you do so, but there are longer term costs to that. And if I can just bring in one anecdote, because thinking also about energy security and energy price caps and policy. We had a guest speaker at my university a little while ago, whose name I can't remember, but he's Czech, and he was given like a special role as some kind of energy security point man in relation to making sure, you know, European energy supplies, EU energy supplies were secure, moving away from Russian dependence. And he talked about like some of the things that were done, right? And, you know, so one of the things that was done is that the EU, which is a collection of what are in the end very wealthy countries in a global context, came in and paid hand over fist to, you know, like say Gulf countries to get oil in a way, and, you know, pardon my French, that just massively screwed over a lot of countries in the global south. And he gave the particular example of Bangladesh, because essentially the EU just came in and paid way over the top to get these Gulf suppliers to break their cheap long-term contracts, right? And like, so why in the end did the EU do that, right? So because it could, and because the overriding priority was kind of effectiveness in that, well, we don't want people to be freezing in winter because then no one is going to support Ukraine and and it's like it's a vital thing. So we just do it. But it has costs. It has costs, and that's, I don't know how you evaluate that in the end.
Formally, we're over time. Again, time is fluid. Jakub.
I would suggest, unless there is urgent question, I would suggest.
There was so.
Oh, there was some other hands. We can take if there is hands. Let's take. Yeah, absolutely.
I mean, we can continue all these discussions after. So much to discuss as well as Nicole, but I would like to ask Kati, because you're someone who originally my degree was to study it, whether you can gaze into the crystal ball and give us your thoughts on Hungary's future, and specifically with regard to its function, how it will function in the EU. How do you think it can and will function in the EU? I mean, it's more of a, I don't know who else to ask it on you.
Any other final?
May I just jump in?
Yeah, go.
Yeah,
Because
I
it relates actually, because it's sort of maybe connecting the previous topic in Hungary now, because I was also very curious, Kati. You can see with how the Commission reacted to the developments in Poland now, the new government and so on. You can clearly see how much has been emphasis put on the goodwill and intention of the government. And so you can see that a lot of like to close Article 7 procedure, a lot of this was needed for it had been actually established by the previous government. Even you can see it's there, but then comes a magic factor, the intention to abide by EU law and by the principle of primacy. So I think what is interesting in this case on the side of the European Union is really this reinforcement of the principle of primacy and intention of the incumbent. So this brings me to Hungary, and my question also, like, what do you think, like, can we, like a situation like that someone comes even from Fidesz after Orban and says, okay, I'm now a convinced Democrat, and I intend to restore the rule of law. Will it be sufficient for the European Union to say, okay, that's fine, and we waive all the sanctions and so on?
Yeah, the extension was not needed. It was like 5 minutes. So
I will try to be brief. I think there are. There are not too many scenarios, right? One is that we are stuck with Orban, and the other one is that someone else comes in or another. And that before I go to that direction, many things depend on how the next 2 years are going to develop. So we do see a candidate at the horizon who the past month, at least in the surveys, has the potential to win elections. That's one scenario. I'm very much looking at Poland, indeed. How could that work out? Of course, it's a smaller country, a different economy, different problems. Also, we never discussed that, but I always feel like judicial independence is not the core of the problems, for example, in Hungary. So many of these rule of law issues, it's much more public administration and these rulemaking, etc. So one scenario is that there will be someone else. We do see it, what you have just said, he comes from deep Fidesz. We will not go into it, but just look at what he's saying with regard to Ukraine. I don't think it's much different than what it was. That's the only person at the moment who has any potential to change the government. I think the EU would, no Orban would be very much changing gears. Maybe we should be a bit more careful there. How the EU is going to be like, yes. The other scenario is that we are stuck with Orban, which I think is also a potential scenario if you look at how they reacted now to seeing that the surveys are going the different direction, starting to revise and change the electoral territories, etc., etc. I think that perspective is it's a fear also, again, because I don't just look at Hungary looking at the government. I think now he has been fully in the spotlight, right? But he's marginalized. He is within the EU. I don't think he will have the same kind of spotlight. We had the presidency. I don't calculate it. There is not going to be a stage like that. So if he is going to stay in power, then it's from both sides going to be some kind of ceasefire where you live with a member state that is in, but which is behaving in an unprecedented way. And you do see that there have been thinkings, right, how to go around that. Maybe not in the most democratic way, but simply to send him out for a coffee break and then say, now the majority vote. So that's the two scenarios I see. I don't think, again, you talked about your lifetime. I also think in our lifetime, we will not see a fully democratic and a Hungary we would have wished for 20 years ago when the changes started. But I'm a pessimistic, and I come from Hungary, so there must be a better scenario.
What a note to end on.
Yeah.
Thanks so much.